So, as someone who's probably looking for divorce help or attorneys, probably seeing a lot of different terms on the internet. What is litigation? What is mediation? These two terms are highly important, and it's important for you guys to understand the difference between them. Mediation is when the parties are trying to resolve the themes of the divorce in a private, collaborative way. Mediation, especially when you are on relatively civil terms with your party, the other party might be the best way to go because you have the most control. You're working with a third-party neutral person with experience in the law. It's usually a certified mediator or attorney, and that person can really streamline things. And if you believe that the other spouse might be more inclined to collaborate, that will be the cheaper and most cost-effective way, as well as it'll speed up the process. Litigation is adversarial. The decisions that will control what happens in your divorce, meaning how the assets will be distributed, custody of the children, that's going to be decided by the courts. You're essentially asking the courts to make decisions because mediation wasn't impossible or it failed. The court in New Jersey really favors collaborative mediation processes as an alternative dispute resolution. Litigation really should be reserved for cases where you and your former spouse simply cannot agree. It is highly emotionally challenging, it is expensive, but the right attorney will hold your hand and guide you through. In New Jersey, mediation is often the most cost-effective and time-effective route. Essentially, in New Jersey, you're only required to pay the cost of mediation for the mediator's fee for the day. If all issues can be resolved within that day period, that typically is the most financially effective way to go. Litigation, where you're asking the courts to decide things, and because things have become adversarial, can be and will typically be more expensive. Why? You're having to pay for motion practice. Attorneys often charge by the hour. So any additional motions or requests that you want the other party to produce will have to be essentially paid on an hourly fee. You're also going to have to pay for document review. Litigation also involves us requesting the other party to furnish or produce certain documents, usually financial documents. Your attorney will often charge you to review those documents and to prepare any motions for interim support, etc. Despite parties' best efforts, sometimes mediation is either not an option or just doesn't reach a resolution. In these cases, it's usually because there are a lot of assets to divide and parties simply cannot agree, or issues of child custody are highly contentious, meaning you just cannot simply agree with your spouse. Perhaps one wants a sole physical custody and so does the other party. In these cases, unfortunately, despite our best efforts, mediation will likely not work in your case, and we must turn to the courts for the courts to help decide these major issues through litigation, which can include motion practice, various different types of hearings, and requests directly to the judge. If you have any questions or concerns regarding mediation or litigation, please do contact us at Next Chapter Family Law. We're here and we're happy to help.